Welcome all to our series of webinars between Mackenzie Presbyterian University and University of Dayton School of Law. Today or tonight or this evening we have with us Professor Jeff Smith, who is the Assistant Dean for Graduate Programs, also Professor of Law, a full-time professor, and he teaches my favorite subject, constitutional law, at the Dayton School of Law. Alongside Professor Jeff, we have Margarete Ioannidis and Walter Hawes, that you already know from the previous webinars. Jeff will be talking about current constitutional issues, a subject that you Brazilian viewers will find really close to what we have been debating right now in Brazil. Jeff, welcome, and please be my guest.
Thank you, and thank you to everyone who's taken time out to participate or listen to this webinar with us. We're really excited about the collaboration. We think it's been going very well so far, and we look forward to continuing that collaboration. In this webinar, we are going to talk about current issues in constitutional law, and then a little bit more about our LLM program and U.S. and transnational law. I teach constitutional law as well as other things, but my focus is on constitutional law, and I actually developed the constitutional law course for the LLM program. And so I'm going to be referring back to that course a little bit throughout my talk here to explain how I think if you take the course, it's going to help you to understand constitutional issues in the U.S. and political issues, what's going on generally in the United States. So the constitutional law course is divided basically into two segments. There's a segment on the structure of the government, how the Constitution basically is a blueprint for the American system of government. It sets up the powers of the federal government and imposes limitations on the states. And so we're going to look at that system in the course, basically what can Congress do, the president, the Supreme Court, checks and balances between those branches, separation of powers, and then limitations on federal power generally vis-a-vis the states. So that's a big part of the course, and it's a big part of what's going on in U.S. politics. I mean, it would, I think, really help you understand issues that, modern important issues in politics in the United States. So I thought I would highlight an example here in this talk, and that is the COVID relief legislation that recently went through Congress. So the American Rescue Plan is one of the biggest initiatives we've had from the federal government in terms of spending money. And the way our system is set up in the US, Congress is limited to its enumerated powers in the Constitution, meaning Congress has limited options available when there's a big national emergency like the pandemic. Congress can spend money. That's what we have here with the American Rescue Plan. Congress can also regulate commerce. That ends up getting broadly interpreted to essentially mean that Congress can regulate economic matters. Congress has other powers as well. Those are really the two big ones, though, the power to spend money and the power to regulate commerce. And we spent a lot of time in the course examining the full scope of the commerce power. It's surprisingly complicated. We need to look at a number of Supreme Court cases to really figure it out. The spending power is a little bit more intuitive. It's a little bit more direct in that Congress can spend money for the general welfare. Okay, so Congress can spend money for the general welfare. There aren't many limitations on that. And of course, Congress, the federal government generally prints money, through the Federal Reserve, buys bonds, issues loans. They have a lot of control. The federal government has a huge amount of control over monetary policy, fiscal policy. It can essentially issue as much debt as it would like. I mean, the Congress has, through statutes, limitations on the debt. Of course, those can always be changed. And a lot of people are willing to lend the United States government money at relatively low interest rates. And so it's pretty easy for Congress to spend huge sums of money. In the American Rescue Plan, we have almost $2 trillion being spent. Trillion, right? That's a ton of money, because Congress essentially can always just borrow money to pay for something that it's doing rather than just raising taxes. It can run at a deficit. The constitutional issue kicks in because of federalism. So under federalism, we have, of course, as I mentioned, limited federal powers. The whole idea behind that is to preserve autonomy, independence for the states. So by saying Congress is limited in what it can do, we're saying that the states have complete control or a certain level of independence over other things, and it actually is fairly extensive. So what Congress is doing here by spending money, that does not raise issues with federalism or infringing on state power. But what Congress almost always does, and certainly did in the American Rescue Plan, is attach conditions to the money that it's spending. So Congress is giving money to individuals and corporations directly, usually with conditions, requirements. You have to meet these requirements to be able to get the money. It's also giving money to the states. And that's a big chunk of what the American Rescue Plan has done, is it's giving money to the states rather than directly to individuals, the state governments. And that is because in the United States, the state governments run most of the stuff that really touches people's lives, like schools. Primary education and public universities are all done through the states. Welfare, most of medicine is regulated primarily through state legislation. And so when the federal government wants to fund those things, what it often does, and what it recently did here for COVID relief, is that it gives money to the states and tells them to allocate it towards these different things, like expanding vaccines, providing unemployment compensation, that's through the states, they're regulated through the federal government, expanding testing, giving money to schools so they can reopen. And the idea here is that Congress wanted to facilitate those things. The states already have the infrastructure set up, so Congress gives money to the states, which then gives it to individuals, to schools, and so forth. Now, that's a constitutional problem because we want to have state independence. We want to have state sovereignty, political power over their own internal things. And so the Supreme Court has developed this test where when Congress gives money to the states, but imposes limitations on what the states can do, sometimes that's unconstitutional because it infringes on state sovereignty. The court has said basically, and that was the issue with healthcare, that was a big issue. One of the biggest Supreme Court cases of the 2000s was about so-called Obamacare, the expansion of healthcare in the US during the Obama administration. And this issue was a big deal then as well. Essentially, the Supreme Court has said that the conditions cannot amount to coercion. They can't be so strict, and so the money can't be so significant that it would undermine state independence and state choice on how to allocate its resources to its citizens. And so for this relief bill, a number of states have filed a lawsuit against the federal government saying that the conditions on all of this money are coercive, that they're unconstitutional. The test is a little bit more complicated than that, but that is the key part of the test that is relevant here for this legislation and, in fact, for Obamacare. The condition that Congress has attached for this is, well, you can only use the money for these certain things, right? Federal government is not handing a blank check to the states. They're saying you have to use the money to reopen schools. You have to use the money to extend unemployment, expand vaccine coverage, things like that. That's not problematic. From a constitutional standpoint, that's okay as long as the conditions relate to the purpose of the funding. So they're giving money to the states for a particular purpose, that's okay. What Congress could not do is give a bunch of money to the states on the condition that they change their criminal laws or something like that that's totally unrelated. That would be unconstitutional because Congress would essentially be using its spending power to force the states to regulate in a certain way that Congress could not do directly, because remember, its powers are primarily economic: the power to spend money, the power to regulate commerce. Now, the condition that Congress has attached here that is potentially problematic and that is being challenged in litigation is that Congress is worried that the states are going to cut taxes, cut expenses elsewhere, because Congress is giving them a bunch of money. Congress doesn't want the states to do that. It doesn't want this to just be funding for the states so they can cut taxes. It wants this to be extra money being injected into the economy, being given to schools, actually being used to expand services. And so as a condition of getting this money, the states have to agree not to cut their taxes. That's the part of the law that is being challenged by the states. And I don't know what's going to happen. I mean, I think there's a plausible case there that the Supreme Court could end up saying it's unconstitutional because the states are in such desperate need and it's such a huge amount of money that these conditions are basically coercive, that the states don't have a real option. They're being forced to take the money, and then Congress is telling them what to do with their taxing power. Supreme Court is concerned that the Congress could use its spending power to, in a indirect way, influence state policy, like its taxing policy, which seems to be what's going on here. I'm not saying these conditions are unconstitutional, but they could be. Now, what happened with the healthcare bill, from back in the Obama years, around 2010, the Supreme Court just cut the conditions out. Right, so the condition there was very different. It was about expanding free medical coverage to families that didn't have a certain level of income, to lower socioeconomic status families and individuals. And the Supreme Court just cut that single provision out. So then the states had to could decide whether or not to take that extra funding, but the rest of Obamacare, the rest of the law, was left intact. They didn't have to do that, though. And in fact, two of the justices, I think it was two of the justices said they should just strike the whole thing down. That would have been possible. It's possible, again, I think, probably by the time this gets to the courts, it may be irrelevant. The money may have been largely spent, but it is possible that the court could actually strike the whole thing down and say that it's unconstitutional because of these conditions. I don't think that's likely to happen at all. I think it's much more likely that the court would just say that the conditions are invalid so that the states can do whatever they want in terms of raising taxes, but it's possible. And these are the issues we would look at in the course. We would be looking at the power of the federal government, the power of the president. Of course, that's another big issue, especially when Donald Trump was the president. There were a lot of debates about executive power, immunity from litigation, from investigation, all sorts of things. We would look at those issues as well. Constitutional, I think, really is looking at a lot of historical stuff, technical stuff, but also the big issues of the day in terms of politics. The other half of the course is looking at individual rights. So individual rights, the big ones are equal protection against discrimination based on race, gender, and sexual orientation are our focuses in the course. Due process, that's fundamental rights. So by fundamental rights, the big one is your right to privacy or personal autonomy in major life decisions. Things like the right to choose, the right to get an abortion, the right to control the upbringing of your children, things like that. And then finally, we look at the First Amendment, two aspects there: freedom of speech and freedom of religion. Those are the big focuses. I wanted to highlight one topic in the talk today, and that's voting rights. This is a huge issue now, a big political issue. We actually had a Supreme Court case come down just a few days ago that most people are saying is the most important decision of the year from the Supreme Court. And it's looking at two state it's all politically charged, whether you call them restrictions on voting or whether you call them voter, protecting the vote or whatever you want to call them, but 2 voting regulations from the state of Arizona. To understand what's going on, though, I think we need a little bit of context. And so in this slide, I just want to talk about how we got here, why the state of Arizona passed new voting regulations. And it's kind of a long story. So United States, of course, if you know anything about it, it has a long history of racial discrimination. It was a slaveholding state slaveholding country prior to the Civil War. And after the Civil War, of course, we have Reconstruction, we have amendments that eliminate slavery and, in fact, guarantee an equal right to vote. However, especially the southern states, because slavery, at least by the time we get to the Civil War, was only in the southern states, slavery was in the South. There's the formal ban on slavery through the constitutional amendments that are passed in the 1860s. And in fact, we have a lot of Black voting, political participation for a couple of decades following the Civil War. That's called Reconstruction. But then we fall into what is called Jim Crow, where we have white people essentially taking over the state governments in the southern states through what is known as redemption. And over time, the white governments then suppress Black voting through state laws and through social intimidation. And so there are things like an all-white primary, where Black people are allowed to vote in the general election, but not the primary, meaning they don't have effective influence on who holds office. We have things like literacy tests, poll taxes, grandfather laws, laws from the state that make it very difficult for people of color to vote. And it's not just the laws themselves, it's also the way in which they are enforced. So for example, with a literacy test, you would have a white voting commissioner who would just, an illiterate white person would be deemed literate and would be allowed to vote. But if you had a person of color who was highly educated, perfectly literate, the administrator of the test would change the test for that individual, make it much more difficult. And even if they passed the test perfectly, the administrator would say that they failed and would prevent them from voting. Or if they passed the test, then often you would have social intimidation and violence to prevent that individual from voting. So long story short, we don't have, Black people are essentially prohibited from voting in many states up until the 1960s. In the 1960s, we have the civil rights movement, and we have meaningful civil rights legislation from Congress that expands the right to vote, in particular, the Voting Rights Act of 1965. Just for an example, in Mississippi, Black voter registration is 1%. 1% of people of color in Mississippi in 1964 are registered to vote. 1% of the people who are eligible are actually registered to vote. By after this law is passed, within a few years, that percentage jumps up to 66%. 66%. So we're going from 1% to 66%. That is huge, right? That's huge. And so the Voting Rights Act does that in a number of different ways. I don't think we have time to get into the weeds on this, but essentially it struck down, it eliminated all regulations that barriers to voting. Things like those literacy tests, those poll taxes, things like that, those were invalidated in one foul swoop. And importantly, the law said that in those states that had discriminated in the right to vote, they were no longer allowed to pass new voting regulations unless they were approved by the federal government. Either the Attorney General or a 3-judge panel had to approve. Now that system was in place from 1965 up until 2013. In 2013, so not that long ago, the Supreme Court in a famous case, Shelby County versus Holder, said that that part of the Voting Rights Act essentially was unconstitutional. It was unconstitutional, the court said, for federalism reasons, actually. It only applied to some states, not every state. It applied to essentially those southern states that had a history of voting discrimination, not the rest of the country. So a state like Ohio, where the University of Dayton is located, could pass whatever it wanted, a voter ID law, any sort of regulation on voting, whereas a state of the former Confederacy, by and large, a state like Virginia, would not be able to pass that type of law. And the Supreme Court, obviously I'm simplifying here, but the Supreme Court essentially said it's unconstitutional because it treats the states unequally. And according to the court, Congress did not have a good reason to do that because the history of voting discrimination that Congress was relying on was so old. By the time we get to 2013, the racial disparities in voting had largely gone away in the South. People of color were voting at very similar rates to white people, at least with respect to, the national average, in the sense that there wasn't a meaningful difference between what was going on in Virginia from New York, Ohio, California, in terms of racial disparities in voting. And so the court said that part of the Voting Rights Act was unconstitutional. So that means that those southern states had free reign. They could pass whatever voting restrictions they wanted, essentially. Now, of course, those could still be challenged in court because the Voting Rights Act still exists in that it prohibits discrimination in voting, right? Any law that would discriminate based on race in particular is still going to be a violation of the Voting Rights Act, and it would violate the 15th Amendment, which directly prohibits discrimination in voting. So these state laws, so a number of these states, they could now pass new legislation on voting, and that's exactly what they did. After 2013, there's a surge of new state laws regulating voting. And those laws, of course, do not facially discriminate. They don't say only white people could vote. That would be obviously wrong and unconstitutional. Instead, they have new requirements or limitations on voting. Things like requiring a government-issued ID when you vote. Purging voter rolls. What that means is looking at you have to register to vote, right? So, and if you haven't voted in a number of elections, taking your name off the registration, so you would need to re-register. Limiting early voting, limiting how people can vote. All sorts of laws that regulate the manner or the time or the place in which someone votes. Now, those laws are being passed since 2013 because of what the Supreme Court did. And in fact, those regulations have increased even more in the last year or so because of all the controversy around the 2020 election. As I'm sure you're aware, we had a big presidential election in 2020, and the loser of that election, Donald Trump, has falsely claimed to this day that there was something wrong with the election, that the election was stolen, that votes weren't properly counted. It's not really clear to me. He doesn't have every court has rejected this claim. The media routinely just says it's all lies, and that's what it is. But he's saying that there's something wrong with the way the election was done, how votes were counted, how votes were cast. Because of COVID, in large part, there was much more vote by mail, early voting than in past election cycles. So it was a little bit different. And Trump has latched on to that to say that change means that there must have been something wrong with the way the voting was conducted. Now, even though his claims are false, people listen to him, right? He was the president. He's the leader of the Republican Party. And so even though those claims are wrong, they've gained a lot of resonance within the Republican Party, and states have passed new laws to address those concerns. And in particular, there's been a lot of controversy over laws that were passed in Georgia that would require an ID, that limit early voting. And as you may have heard, sports affiliations have even pulled out of Georgia, Atlanta. There's been a lot of controversy over this. There's First Amendment concerns. But I'm going to focus on Arizona. I'm going to focus on Arizona because that is the laws in Arizona are what prompted the recent Supreme Court case from just about a week ago. So this is Branovich versus the Democratic National Committee. And these Arizona laws did two things. First of all, we have what is called the out of precinct policy. That's provision number one that the court looks at, and then we have a limitation on ballot harvesting. So, and as I mentioned, there's all sorts of different regulations that the states are passing here to regulate, to change the way in which voting is done. Typically, we're looking at the time, manner, or place of voting. So, an out of precinct policy, what Arizona has done there is saying that if you're going to vote on election day, you have to you're in a certain county, you have to vote in the designated place for that county. If you go somewhere else within Arizona and vote, your vote will not count. It simply will not be a valid vote. It won't count. The second restriction here is called ballot harvesting, and Arizona allows people to vote by mail or to vote early, before the election at particular locations. And what ballot harvesting does is it makes it a felony, a serious crime for anyone to collect and deliver another person's ballot. Now, there are exceptions. There are exceptions for family members. So if my wife, and this actually happened, right? So I voted by mail, I voted early in the last election. My wife got our ballots, took them to a ballot drop location, dropped them off. That would not be a violation of this law because she's in my immediate family. But if my brother had done it, who's not within my immediate household, he would have committed a felony. He would have committed a felony because under this law, you're not allowed to mail or deliver anyone else's ballot. So the DNC filed a lawsuit here. Their argument is that this violates the Voting Rights Act, the VRA, because it produces racially disparate results, and they claim it was enacted with a discriminatory intent. The Supreme Court disagreed. Supreme Court held that these laws were constitutional. And this is seen as basically the Supreme Court giving a pretty clear signal that it's going to do the same thing with most of the other voting laws that have come out, including that law in Georgia. We don't know that for sure, but that's probably the case. So in interpreting the Voting Rights Act, the key statute here, the court has said that the question is not limited to whether there is a discriminatory impact based on race. Instead, what we're supposed to look at is whether the vote is equally open, so that there's an equal opportunity to vote. That's the touchstone. Whether voting, the opportunity to vote, is equally open to everyone along race, gender, national origin, sexual orientation, all of those things that we're worried about discrimination on, particularly race, right? Because of that history in the United States. And we're going to consider racial disparities in impact, but it's not the only thing the court's going to look at. So in applying that standard here to what Arizona had done, the court said it's going to consider a number of factors. I've highlighted what I think are the most important ones. They say, first, we need to ask, has the state made it difficult to vote? Is it overly burdensome? If it is relatively easy to vote, then the vote is equally open and there's an equal opportunity, even if there is some statistically significant impact, essentially. And the court here says, if you look at the statistics, throwing out those out of precinct votes when you vote in the wrong place, that's not a big deal. because looking at the 2016 election, the last election that they had data on, only about 1% of people who voted in that election on election day voted in the wrong place. And it's, in fact, it's actually a little bit less than 1%. So for people, and then they broke it down by they looked at the racial disparity as well. With that particular policy, about 1% of people of color voted in the wrong precinct and had their votes thrown out. If you look at white voters, it was about 0.5% of those voters voted in the wrong place and had their votes thrown out. So if you look at those statistics, it's really subject to interpretation, right? Because you could say it's a very small absolute percentage. Barely anyone is having their votes thrown out, 1% to 0.5%, depending on what population you're looking at. And in absolute terms, there's only 0.5% difference between white votes that are getting thrown out and votes from people of color. There's a dissent, though. This is a 6-3 decision along partisan lines. The conservatives all vote to uphold the Arizona law. The liberals all say it should be invalid. What the liberals say in dissent is that you shouldn't look at it from absolute numbers. You should look at it comparatively. What I mean by that is the statistics here show 1% of the votes from people of color are thrown out, 0.5% of the white votes are thrown out. That means twice as many votes from people of color are getting thrown out. If you look at the incremental impact, there's a big racial disparity. And so we should see this provision as essentially racial discrimination that should be invalid. That's the dissent, though. That's not what the court says. Looking at the other provision, the ballot harvesting, the court says, we don't have any statistics on this. No one has a clear record as to how many ballots are actually being collected, how many people are doing this, or what the racial disparity is, if any. And then, of course, we have to look at that last factor, what's the state's interest? So the out of precinct voting, the court says, the interests here are relatively minor. It's to prevent voter fraud, and it's to have an easy administration of the vote. So for the out of precinct policy, the states want to make sure they have enough poll workers, they have things staffed enough, so they have enough capacity there when people go and vote. So we need to tell people where they can go to vote. If everyone shows up at the same place, it's not going to work. And the court says that's a legitimate interest. And it's enough of an interest to justify the policy, given that there's not much of a burden and not much of a racial disparity. Looking at the ballot harvesting policy, the court says there's a legitimate state interest there in preventing fraud. People could apparently, it's possible that someone could print up ballots and fraudulently turn them in. There's no evidence of that ever happening in the past, but the court says that the state can be proactive. I think more relevant here, or a better state interest that the court gives more weight to, is a concern about influence and intimidation. The court says if someone's going around knocking on doors, trying to collect votes and then deliver those votes, it's probably because they care an awful lot about the election. They may influence people. They may get people to vote who otherwise wouldn't vote. They may get people, they may try to convince people to vote for a particular candidate and coerce them into doing so. And so the court says that the state has a legitimate interest in making sure that voting is private and that there's no undue influence. The dissent says that there's no real state interest here, there's no voter fraud, those interests are pretty speculative and minor. And on the ballot harvesting point, even though there's no statistics, because there are just no studies done on this, we don't have numbers on it, the dissent spends an awful lot of time talking about how this will disproportionately affect communities of color. In particular, Arizona has reservations for Native Americans. So Native Americans, by and large, had been, it's a long story here. I could talk about this forever, right? Native Americans had been pushed out of their ancestral lands over, the course of U.S. history throughout the 16, 17, 1800s. And the federal government has created reservations on federal land where Native Americans have sovereignty to some extent. That's actually a big topic within it of itself, Indian law. And on these reservations, often there is no direct federal postal service. What that means is individuals who live on these reservations, and these reservations are primarily out west, states like Oklahoma, but also Arizona, you have significant populations of Native Americans who are voting, who have to travel long distances, not just to vote, but also to be able to use the mail. And so this ballot harvesting was a way for these Native American communities to get people to vote, because someone would collect votes from the community and then make the drive into the post office. And these communities often don't have a lot of means. Many of the families don't have access to a car to drive in and deliver the ballot. And so the dissent says this will have a disproportionate impact on communities of color. Communities of color, minority voters, it's racial discrimination. It's racial discrimination because of that impact that would occur. More people of color will be prevented from voting because of these regulations. Again, the majority says that's all speculative. We don't have hard evidence on it. Taking a step back, that's looking at, is the vote equally open? Is there an equal opportunity to vote? Well, the court says yes. In Arizona, it's pretty easy to vote. You can vote by mail. You can vote on election day. It's just they're adding these minor restrictions. Well, the DNC also says that this should be struck down. These laws should be struck down because there was a purpose to discriminate based on race. That the legislature really was trying to stop people of color from voting by passing these neutral-looking laws. Again, the Supreme Court rejects that argument. The court says there's no clear evidence of a discriminatory intent. If you look at the legislative history, people aren't saying that there's a discriminatory intent. There's no solid evidence of any disparate impact. And the court says that there are race-neutral reasons, what I mentioned earlier, facilitating Arizona being able to administer the vote in an even way. So there's no direct evidence of an intent to discriminate, legislative history, and there's no circumstantial evidence of discrimination. Not a big impact. There are other reasons Arizona might have done this. And that's a big issue. When we look at equal protection doctrine within the LLM course, we spend a lot of time talking about how the court addresses equal protection in the modern era, because usually the legislature doesn't just come out and say, we're going to discriminate based on race. Instead, in the modern era, they will typically pass what we call neutral laws, facially neutral laws, that tend to affect people differently based on race. And the court has a big, a ton of case law on this, a lot of jurisprudence about what to do with those laws. Long story short, one of the big things we look for is an intent to discriminate. If there's intent to discriminate, the law will virtually always be struck down. Unless there's an affirmative action plan, then usually it'll be struck down, but occasionally it'll be upheld. That would require a lot more time than I have to deal with in this presentation. So the court says the vote is equally open. It's not an infringement on the right to vote, and there's no evidence of an intent to discriminate based on race. A lot of people are unhappy with this decision. The allegations that we get here from the Democratic National Committee, journalists, a lot of commentators and academics is that through laws like this, the states are trying to make it harder to vote, particularly for people of color, for partisan advantage. And that's another big issue that is lurking in the background here, is that race and partisanship are highly correlated, right? People of color vote disproportionately for Democrats. Certainly not always, but statistically, most people of color vote for Democrats. And so then these voting restriction laws are being passed by Republican-controlled state legislatures. And the allegation is that they're trying to make it harder to vote for Democrats. And in particular, if you want to target legislation towards Democratic voters, the easiest way to do that is to target urban areas which tend to vote Democrat and minority areas which tend to vote Democrat. And so there's partisanship that's being mixed in here as well, which can raise First Amendment concerns, freedom of association, freedom of speech, but I'll leave that for another topic, another talk. Okay, so that's, I've been going on and on now for I think more than 30 minutes. I would love to hear any questions anyone has. I'd love to have a discussion here. I know that you're facing some of these same issues or similar issues in Brazil, so I'd love to talk about that and invite any questions or comments you have.
Thank you, Jeff. It was indeed really interesting. This bird's eye view regarding visual rights and also the federal recovery package, which, as a matter of fact, is a current issue also here in Brazil. Lila, she asked if she could have access to your PowerPoint presentation.
Of course, yeah.
Let us see then if our students, if they want to ask any questions. Lila, Beatriz is writing down. I can see it. All right. No, it was just a thank you note.
Well, you're very welcome. Happy to answer questions about the program as well, but yeah.
Yes, Ingrid here. She wrote it down. It's about the application process. Ingrid, after we can talk about your questions with Margaret, all right? She has a specific question about the application process, Jeff.
Okay, yeah, that's probably better addressed to Margaret, but
Yeah, don't worry.
Talk about the program itself. I did develop the constitutional law course and know the program fairly well. Yeah.
Well, okay. Thank you very much, Jeff. It was really interesting, and we can see that it's an ongoing issue, and how even though the states and also with the national and the civil rights movement back in the 60s, there is still this entrenched desire to try to hinder equality in terms of voting and democracy. And we need to keep a constant watch and oversight to maintain the democratic approach and equality. Thank you very much, Jeff. Margaret?
You're welcome. Thank you for giving me the opportunity. So, thank you.
Thanks, Jeff, and hi, Pedro. Another great presentation by Dean and Professor Jeff Schmidt, also better known as the course developer for our constitutional law course in the online LLM program. So we are actually offering that course this semester, and students have enjoyed it as they have every year. So just a quick question. I wanted to make sure, is everyone able to see the slide deck and with the slide on University of Dayton School of Law?
Let me see it. On mine, I can see, but I have changed your slide. I can see your photo and presentation.
Okay, perfect.
Yes.
So yes, you're able to see it?
Mm-hmm.
All right, perfect. Well, hello, everyone. Thank you again, Pedro, and thank you to everyone for joining us today. I recognize actually a number of the participant names, so thank you for taking the time to join us, and yet again, another webinar that we've had. I will be happy to answer any questions about the online LLM program as well as the application process. As Pedro mentioned, I am the program director, which means I work with all aspects of the program, including the admissions and recruitment stage, and covering the academics as well. So I have that wonderful privilege of getting to work with students as they are thinking about starting the program, and then once they're in the program, and then even those who graduate from the program and then move on to either take the bar exam or move on professionally. So I'd like to give a little bit of background about the University of Dayton School of Law and the LLM program in particular. The University of Dayton School of Law is actually accredited by the American Bar Association, which is the accrediting body for law schools in the United States. Historically, we'd offer an on-campus LLM program in American and transnational law. And starting in 2019, we began offering a fully online option. So students are able to earn the same degree that they would have otherwise had to travel on campus and spend 1 to 2 years on campus to pursue the LLM degree. They are now able to pursue the exact same degree 100% online. By offering this fully online option, we were able to expand access to the program and also to make it more affordable for the program. So there is no visa requirement and there is no travel requirement in order to pursue this online LLM degree. And also because there is no visa requirement, we're able to have a lot more flexibility in terms of how many courses students take each semester. So we are able to give students that flexibility. If they only want to take 1 or 2 courses per semester, that is fine. And students have up to 3 years to complete the LLM degree. It actually can be completed in as little as 8 to 12 months. For the students pursuing the LLM 100% online, the curriculum is focused on US law and legal practice. So we actually will have the full curriculum on the next slide or so. We have 3 semesters per year. One begins in January, one in May, and one in August. So we actually are currently recruiting for the upcoming August semester that begins on August 23rd. There are normally 12 courses in the 30-credit curriculum, but through the partnership that we have with Mackenzie University, we're actually able to recognize credits from the coursework that you have completed as part of your studies at Mackenzie. And so as a result, students are able to complete the full LLM degree with only 20 credits, which corresponds to approximately 8 courses. And with that, you're able to earn the degree within 8 months, 8 to 12 months, or you can take as long as 3 years if you only want to be taking 1 course per semester. We've included here some additional information about the partnership highlights. For those of you who are currently pursuing your bachelorette degree, you are able to start the LLM as soon as you have completed 7 semesters of study. For those of you in the master's program or those of you who have already completed your bachelorette studies, you are able to start at any time. And under either scenario, as I mentioned, we are able to recognize up to 10 credits from your Mackenzie studies towards the LLM degree. Through the partnership, we are also able to offer a guaranteed scholarship to students that are interested in the program. This scholarship is applied per credit that a student pays and reduces the total cost to approximately $9,500 US. This is approximately a 75% reduction in the cost of the LLM degree. So we're really pleased to be able to offer this. Tuition is actually paid each semester based on how many credits a student is taking per semester. And so we've included here the example for 1 credit. The per credit tuition rate is normally $1,237 per credit. We offer a guaranteed scholarship of $762 per credit. And so the total cost would be $475 per credit. So again, if you only took 2 credits, which for example would be the Introduction to U.S. Law course, which is required for all incoming students, the cost for that would be $475 times 2, which would be the total tuition rate. As you can see, the diploma is the same, whether you pursue the degree online or on campus. And we have included the curriculum here. So these are the 12 courses. We have included in green the courses that you would have to take under this partnership. So that's 5 courses. The remaining 3 courses, which would correspond to approximately 8 credits, you would be able to select from the elective courses that are listed here. So we are currently accepting applications for our next semester that begins on August 23rd. The deadline is coming up July 23rd, and we do take about 1 to 2 weeks to review those completed applications. I know that there had been a question about the application process. So Walter Hawes and I would be the points of contact for answering those questions. Basically, you would complete the application that is available online on our website under the special landing page for Mackenzie University. You are able to scan all of the documents into one file and email them to Walter or myself, or to the online LLM at udayton.edu email address. And so included within that, you would have not only the application, your updated CV or resume, your personal statement, proof or alternate proof of English proficiency. If you have not yet taken the TOEFL or the IELTS, we can accept alternate proof of proficiency, and your government issued photo ID. The only thing that we will need independently would be your transcripts from Mackenzie University. If you're a current student, we can get those directly from Mackenzie University. If you have already graduated, then those transcripts will need to be provided to a credential evaluation agency, one of which is Spantran, and we have that link included on the website as well, and they're able to complete that credential evaluation. We also have several webinar events, including our Law in the Americas series. Our next event is coming up on August 19th, and we'd encourage for any of you who are interested in the field of copyrights or the impact of copyrights and COVID vaccines to please visit our website. You can register for the event. It is open to the public, so feel free to invite your friends as well. And so with that said, I will stop talking and see if there are any questions.
Thank you, Margaret.
Thank you, Pedro.
Ingrid, are your both questions answered, or would you need require any further clarification? All right. While we wait for Ingrid, any other students who would like to address another question? Alguém gostaria de fazer mais alguma pergunta? Let us. Margaret, Ingrid didn't get the answer about the application process.
Okay. Sure. So Ingrid, if you the information that you've provided here is, I believe, from the website that we have. So there would be you would complete the application for fall 2021. We have the fillable PDF on our website page, and specifically on the Mackenzie landing page. I can post that in the chat as well. And so you are able to fill that out, and then you can email that directly to Walter or myself, along with your other application documents. You can send each document independently, or if you want to combine all of them into one PDF, that's fine as well. We are very flexible in terms of how we receive the applications.
Ingrid, ela vai aqui colocar o link, né, para o application, e aí também você tem um e-mail que você pode enviar os outros documentos. Eu também estou colocando aqui, Ingrid, o contato do COI.alunos também que pode te ajudar com qualquer dúvida e questão que você possa ter durante esse processo de aplicação, tá bom? A gente já está ficando especialista nesse processo de application. I'm just saying, Margaret, that we are becoming experts also at your application process.
Thank you, Pedro.
All right. Margaret, you're gonna share the link, right?
Oh, yes, yes. Actually, I'm looking for that right now. So.
All right. Rodrigo is saying that he's enjoying our webinars a lot. So Jeff, you already have a fan here at our chat.
That's great. Thank you. I appreciate it.
And Beatriz was also asking me questions about your presentation and the subject. She's gonna listen to the recording.
Yeah, please feel free to send me an email, or I'm happy to talk.
That's great.
I just entered the application information in the chat, and so that will have the fillable PDF is available there, as well as the step-by-step instructions. And then also feel free, I will include my email in the chat as well. Oops. Oh, it's not working.
Thank you, Margaret.
You're welcome. Thank you. Had a little bit of technical problems here working with Teams. As background, we use Zoom for within the online LLM program. So.
Yeah. Oh, and besides that, you were facing a hurricane and a tropical storm now, right? So. Okay. Any other question? Okay, if there isn't, I would like once again thank specifically Professor Jeff, Margaret, Walter, Mariana Baeta on behalf of our law school, Diane, and all the students that took their time and their vacation time to get to know a little bit more about the American legal system, which was an amazing subject, Jeff, outstanding, and to get to know a little bit more about the application process. If there is any other doubt about either the content, please feel free to send an email to Professor Jeff, or regarding the application process, please reach out for koi.alunos@mackenzie.br, or reach out for Margaret or Walter. We will happily answer to all your doubts and questions. Have an amazing Thursday, keep safe. And for the Brazilians and people in the state of São Paulo, have a nice holiday.
Thank you. Bye-bye.
Bye-bye.